Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. Today we're going to talk about paternity law in Illinois. We have a really extensive article about this on our website, learn-about-law.com. So if you want more detail, feel free to check out that article. But first, let's start with an overview of what we're going to talk about today. First, the Illinois Parentage Act of 1984 governs paternity cases in Illinois. Basically, it deals with any issues revolving around children born out of wedlock. So we're going to talk about three different causes of action for paternity in Illinois. One is a case that's filed with the court to establish paternity by consent of the parents. The second is contested paternity suits where the parents don't agree on who the father is. And the third is suits to establish the non-existence of a father-child relationship that can be filed by the father. We're also going to talk about how paternity affects child support and child custody issues. So let's get started. So the first thing we're going to talk about is establishing paternity by consent of the parents. So oftentimes parents aren't married, but they agree on who the father is, and the father isn't going to pose a problem. This is the easiest way to establish paternity. Hospitals are required when they're non-married parents to present two forms: a verified petition to establish paternity and an order establishing paternity that the court can sign. And the parents just, if they want to agree to establish paternity, will sign these forms and then hire an attorney to file them with the court. The order will reserve issues of child support until a later date. But basically, this mutually agreed paternity suit saves everybody a lot of attorney's fees and is a very simple process. And it's the most common and easy way to establish paternity. Next, let's talk about contested paternity suits. So these are suits where the parties don't agree, the father's not accepting paternity. These suits can be filed by the father, by the mother, by the child, by anyone with custody of the child, or by any entity that's providing financial assistance to the child. The child will be represented by their legal guardian, but often the court will appoint a guardian ad litem, which is basically an attorney that's assigned to represent the child's best interests as opposed to that of one of the parents. It can be filed in any county where any of the parties resides. And one of the important parts to talk about here is the statute of limitations. So this is different between suits establishing paternity and suits to establish the non-existence of a father-child relationship. If it's a suit establishing paternity, the suit can be filed anytime until the child reaches the age of 20. If it's a suit to establish the non-existence of a father-child relationship, it has to be filed within 2 years after the date that the father knows or should have known all the relevant facts leading to his fatherhood. So next, let's talk about the concept of the presumed father. There's a presumption of fatherhood that arises when one of four statutory factors is true, and we'll go over what those factors are later. If that presumption arises, then there's a higher standard of proof that's required, which we'll also talk about later, to disprove fatherhood. So if there's a presumed father, the parties have to show something higher than greater than 50% chance of likelihood that that person's not the father in order to disprove the fatherhood. The other reason presumed fatherhood is important is that the presumed father is entitled to notices and may be required to sign certain documents throughout the procedure of the case. So let's talk about what gives rise to presumed fatherhood. First, it's anyone that is married or in a civil union or a similar relationship when the child is born. And for the rest of this conversation, we'll talk about civil unions and similar relationships to be encompassed by the term married. So anyone who's married when the child is born is the presumed father, married to the mother, obviously. Anyone who was in a marriage that terminated within 300 days prior to the birth of the child is also a presumed father. Anyone who marries the mother after the birth of the child and is also listed on the child's birth certificate is a presumed father. And finally, anyone who is in a marriage or civil union or similar relationship during or within 300 days prior to the birth of the child that was later invalidated. So this is something where it was an annulled marriage, but the parties in good faith tried to go through the proper legal channels to marry. So that fourth one is probably the least common and also the most difficult to grasp. So don't worry if you're not getting it. But that's basically if the parents tried to marry before the birth of the child, and that marriage was annulled, but they thought they were getting married than the presumed father. So basically, presumed fathers have to do with the relationship between the father and mother before or after the birth of the child, and the different factors that are required to give rise to that presumption of fatherhood vary based on the timeline of the marriage. So next we're going to talk about how to prove paternity and the standards of proof that are required in different situations. So first, the baseline is that the petitioner has the burden of proof to prove paternity by a preponderance of the evidence. So this could be the mother, this could be the father, this could be the child. It's whoever filed the suit to prove paternity. And the preponderance of the evidence means that the petitioner has shown that more likely than not, so 51% chance, the facts show that the person who they're seeking to prove is the father. In the case of a presumed father, which we just talked about, if there's a presumed father in the case, then that presumption of fatherhood can only be rebutted by clear and convincing evidence. And that's a higher standard of proof than a preponderance of the evidence. So it's got to be more than a 51% likelihood. The evidence has to be clear and convincing to rebut the presumption of a presumed father. Clear and convincing evidence is also required in the case where one of the parents has passed away and the establishment of paternity is for the purpose of heirship. So basically, if one of the parents is dead and you can't get their testimony and someone's claiming to be their child, they have to show by clear and convincing evidence a higher than normal standard of proof that they're the child. Let's talk about acknowledgement of paternity and how that works. So if someone signs a voluntary acknowledgement of paternity, then within 60 days of signing that form, or within 60 days of the filing of a paternity suit, whichever comes first, that acknowledgement of paternity becomes conclusive. And that means that it can only be overturned, that acknowledgement of paternity can only be overturned by a showing of fraud, duress, or a material mistake of fact. So how do DNA tests work in paternity cases? DNA tests aren't necessarily required in paternity cases. There are other ways of proving paternity and for the petitioner to meet their burden of proof. But the court or any party can request a DNA test. If a DNA test is requested, the person who it is requested of does not have to take the test. But if they don't, they're most likely going to lose the case. If a DNA test is accepted and it's undergone, then either party or both can hire experts to analyze the results of the test. If the experts agree that the test does not show paternity, then the case is most likely going to be dismissed. If the experts disagree, then their testimony is weighed against one another in the evidence in determining whether the burden of proof has been met. So there's something called the Combined Paternity Index, which shows how it's basically a number that shows how likely that the test is to show that the person is the father. The father is actually the father of the child. And the higher the Combined Paternity Index, the more likely it is that that person is the father. There's a threshold that's set where if it's over and above this certain threshold of Combined Paternity Index, then the evidentiary standard rises to clear and convincing evidence to rebut the test results showing that that person's the father. So if the Combined Paternity Index number is high enough, then it's going to be pretty good evidence and it's going to be really hard to rebut. So think of it like a spectrum. You know, the paternity test can show conclusively that the person is not the father, but it may show that there's a certain spectrum of likelihood that the person is the father. If it reaches a certain threshold on that spectrum, you have to rebut the test with clear and convincing evidence, which is hard to do. If it doesn't rise to meet that threshold, then it's weighed along with all of the other evidence in the trier of facts assessment of who the father is. So let's wrap up by talking about how paternity works and interacts with child support and child custody. This is pretty simple. In child support, in paternity cases, it's treated just like child support in divorce cases, except for two exceptions. One is that in paternity cases, the courts are much more likely to award the costs of the pregnancy as child support. The second is that in paternity cases, courts are also much more likely to award retroactive child support, so child support from before the date that the case was filed. The reasoning is that in divorce cases, unlike paternity cases, the parties were married before the case was filed, and presumably the father was contributing to the care of the child during that time. In paternity cases, there's no assumption that the father was contributing to the care of the child before the paternity case was filed. So a lot of the factors that the courts look at in determining whether to award retroactive child support revolve around the interactions of the parties prior to the time the case was filed. Things like, did the father know that the child was his? Did the father offer to pay child support and was denied? Did the parties discuss this ahead of time? So the more opportunity the father had to pay child support before the filing of the case that was not taken, the more likely it is that retroactive child support will be awarded. Child custody is treated almost exactly like divorce cases. Non-married parents have the same rights relative to one another with respect to custody as married parents do, except to the extent that the best interests of the child are affected by the different situations, so the lack of a marriage beforehand. But the baseline is custody is treated exactly the same, and again, child support is treated the same as in a divorce case, except for those two exceptions we talked about earlier. We have a lot of articles and videos about how child support and child custody work in divorce cases, so if you want to get a baseline knowledge of that, feel free to go to learn-about-law.com to check out those articles and videos. And again, we've got a lot more detail on this article about paternity on the website, so check that out too. Thanks so much for listening.
Thanks for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit makingrealestatefun.com for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.